Colleagues, I usually begin sessions saying that we didn't wait for anybody. But in this case, the time has already started and we're not beginning it. I know that the second session that we're working in another hall have just joined us, but still, we have to begin our second plenary session. So, colleagues, right now I would like to give floor to our esteemed colleague, the esteemed classic, Mr. Eduard Gavrilov. Many of us learned from his textbooks. He's now professor and researcher at law faculty of the Higher School of Economics and associate member of the UNESCO chair. And he's been this associate member since 1999, since the very time the UNESCO chair on copyright was established. Mr. Gavrilov, by the nature of his scientific work, by his research work, by his mentality, he's a person who looks in the very distant future. He's a visionary. He's a digital researcher, if I may. But he hasn't any internet connection at home yet. So, in this respect, we can call him a lamp receiver. So we cannot talk to him directly, we cannot talk to him over a video conference. But his grandson has helped him to record his speech, and we're going to listen to the speech right now. So please, launch the speech. Dear Chairman, thank you very much for the invitation to participate in this Research to Practice conference. I think it is raising a very topical questions and it's very useful. The topic of my report is legal protection of industrial designs and trademarks in the context of other intellectual rights in the Russian Federation. The basis of my report is about copyright of industrial designs. So, legal protection of copyrights, of industrial designs in the Russian Federation began in 1864. Then, after the October Revolution 1917, this protection was made null and void and was only restored in 1924. And it was in force until 1936. Then it was stopped, and it was restored starting from July the 1st, 1965, from the time the Soviet Union joined the Paris Convention on the Protection of Intellectual Property, dated 1883. This was the golden age back then. The so-called Premier Kosygin reform was just completed, and as the results of these reforms were developing, the USSR joined the Paris Convention. On July the 9th, 1965, our Russian Soviet law on legal protection of industrial designs was adopted. It was built based on the registration system, and back then we saw a major surge. We saw a new science of technical aesthetics appear. Magazines on technical aesthetics began to be published, and it was proclaimed that it wasn't about science, it wasn't about technology, it wasn't about art, it was a totally different phenomenon. It was stated that a beautiful plane would fly and an ugly plane wouldn't, that beauty would save the world. And then we saw this new non-Russian word, design, a design project, which meant an idea, a concept. So this was an English word which was introduced into the Russian language and became a Russian word. And we saw a new word appear in the Russian language, the word designer. And now we'll tell you how industrial designs started to appear starting from July the 1st, 1965. So these designs were registered, certificates would be issued, and in certain cases patents would be issued for these designs. But they would not depend either on copyright or on the patent right. Then we saw perestroika come to the USSR in 1985, and back then industrial designs started to fall under the patent law. They were made similar to inventions and useful models. The idea, the concept was expressed in words. The patent law started to apply to industrial designs, and industrial designs became a foreign body in the field of patent right. The whole world registers based on two principles, the novelty and originality. These principles of novelty and originality are two different principles. They cannot be combined. A poet said that it is impossible to harness a row and a stud in one carriage. So, in a similar fashion, novelty and originality cannot be combined in one regulation. So, what happened then to our laws in the beginning of this century? Russian law changed. We all know this well-known expert, Ms. Olga Alexeyeva. Her father was Lenor. This is an acronym. Len is the father of the revolution. Lenor. So Olga, daughter of Lenor Alexeyev, Olga Alexeyeva, carried out heroic feats. She examined European laws, and she decided that industrial designs should be determined not in words but in visual forms. And this is the only right approach. We all may remember a well-known painting in the Russian Art Critics Gallery where Ivan the Terrible kills his son. You can see it in the gallery. You remember it. You all remember it. So Tsar Ivan has just hit his son with his stick on the head. The son is lying on the floor, bleeding and dying, and the Tsar Ivan sees what's going on. He sees that his son is dying. He's looking at him, terrified, and his eyes, what his eyes show, vamp woman, and she's asking, why are you drinking this terrible liquid? Or maybe she's asking you, why are you drinking this excellent vodka without me? So this is something which cannot be expressed in words. This means that industrial design can be only expressed in a visual way. Now, that said, worldwide, industrial designs could not be made either part of the copyright or patent right for several hundred years. In France, for instance, the industrial designs were protected in a fashion similar to copyright. Starting from 1806, Napoleon decided to protect the laces made in Lyon, and in the US, slightly after that, industrial designs were protected by patent law. So let us conclude. What am I proposing with respect to industrial design? I'm proposing to do the following. Industrial designs should be made a separate, an item of separate law, a law on legal protection of industrial designs. This law should provide for the following: registration of an industrial design based on the principle of novelty and originality. First, an industrial design should be published, then it can be registered, and if it is registered, then this registration will be valid for 25 years from the day of registration. They can be 3D and they can be flat, two-dimensional. 3D designs are models, 2D designs are drawings. They can include trademarks, among other things. Industrial design is the result of creative work. But the creator of an industrial design should not be termed the author, though, because then this will bring us into the application of the Berne Convention on literary artistic work, and we will have to protect their rights for 70 years after their deaths. And in this way, we will only have to protect them for 25 years from the date of registration. Industrial designs at the moment are protected by the copyright in the Russian Federation. They're termed as results of decorative and applied art, and they're registered as registered by the Russian Copyright Society. In other words, the system which is currently in existence in Europe should be adopted in Russia too. We can take the system which exists in the FRG, for instance, where starting from 2001, industrial designs are termed designs. The German language also adopted this English term. Previously, they would term them Geschmacksmuster, which means examples of taste. And now they have another word, design, in the law on legal protection. That said, the German system doesn't quite suit us, because a design must only be protected by a particular law, either copyright or patent right, either on the basis of the principle of originality or on the basis of the novelty principle. I don't think we should divide this single asset into separate types of intellectual rights. At the moment, the Federal Republic of Germany, in accordance with the law on design protection from 2004, protects industrial designs both by copyright, patent right, and the right on trademarks. We cannot allow multiple ways of protection of this asset. Let it be a single type of protection. In other words, we cannot agree with the way it is done in Germany. When an industrial design is registered, both copyright and patent right and trademark right can apply to it. This is the conclusion we should make. After the applicant has registered the industrial design, it can fall under one right exclusively. In my opinion, this should be industrial right, which would be similar to patent right. There's a great difference between copyright and patent right. Patent right proceeds from the novelty principle. There can be several items at the same time, several assets. For instance, you can, one person or another person can invent a radio. In copyright, but the copyright knows only one author. A patent right allows several authors to exist at the same time. And then this causes a dispute about the priority. Who was the first? The copyright provides for only one right. There cannot be such dispute. A unique work can be made by only one person. An original, a unique work can be made by only one person. None other person can create it independent of that person. Furthermore, there are other differences between the copyright and the patent right. In copyright, we see individual parts of an asset protected. They can obtain protection if they're used separately from the entire work. If there are pieces of work in themselves. In patent right, an asset is protected as a whole. To conclude, I would like to say a few words about trademarks. I have one very complicated question in this respect. It is laid forth in the article. It is related to paragraph 9 of Article 1483 of the Civil Code. Copyright, patent right, and right to a trademark, and other rights which are included, which apply to the trademark. This article was analyzed on many occasions, and I realized only a short time ago that this implies three rights: copyright, right to a trademark, and the so-called concurrent right. It's a special public right which also exists there. My latest publications that have been made over the past years are available in the magazine Patents and Licenses, Intellectual Rights. You can also find these publications in publications by Moscow publishers Juris Sovetum. I have also published articles electronically in Consultant Plus and in Garant.ru. Thank you very much for listening to me. Let us thank our dear Eduard Gavrilov for his most interesting speech, which raises issues and offers most interesting solutions. Although I couldn't agree with all of them, but this is not so important, because we have freedom of speech, which is provided for in the Constitution. So likewise, we have freedom for our scientific research. And now I'd like to give floor to our US colleagues, professor of the Illinois University, a member of our chair of UNESCO, Mr. Peter Maggs. Professor Maggs, can you hear us?
Большое спасибо. Большое спасибо. Сегодня хотелось бы хотелось бы поблагодарить организаторов мероприятия и хотелось бы перейти к обсуждению темы новых подходов к проблеме функциональности товарных знаков в Соединенных Штатах.
I've put into chat my email address, the address where you can download my complete paper, and a mention of a Supreme Court decision that was decided last week after I had submitted this paper, a very important decision in this area of conflict between different types of intellectual property protection. In particular, the Supreme Court was faced with the copying by Google of 10,000 lines of Oracle's application program interface. It held this was fair use, but it made no decision on whether or not the application interface was proper.
Я также в чат направил свой имейл и информацию о том, как Верховный суд США рассматривает решения, связанные с правовой охраной объектов интеллектуальной собственности. Я думаю, участникам должно быть интересно.
Now, I'd like to turn to my talk.
Сейчас хотелось бы перейти непосредственно к своему выступлению.
Art protection, utilitarian functionality, and aesthetic functionality.
В своем выступлении я, конечно же, затрону два основных аспекта, которые связаны с товарными знаками в США. Это аспект функциональной применимости и аспект эстетической функции товарного знака.
Graphic side. The classic example of aesthetic functionality is a red heart-shaped box for Valentine gift candy. The box is physically better than any other type of candy box, but no other box would make the same symbolic expression of love.
Классическим примером эстетической функции товарного знака мы можем рассмотреть красную коробку в форме сердца, которая является подарочной коробкой для конфет ко Дню Святого Валентина, что по своей сути ближе по определению в российском законодательстве к промышленному образцу. Тем не менее, в США это подпадает под закон о товарных знаках и относится к эстетической функции.
Unless it comprises any matter that as a whole is functional. However, the Trademark Act does not define functionality, so the actual scope of the functionality principle depends on court interpretations.
Также, как я упомянул, основным аспектом является аспект функциональной применимости товарного знака. Ярким примером такого определения является дело, рассмотренное Верховным судом, который постановил, что опора с двумя пружинами была практически применима для установки переносного дорожного знака. И зачастую аспект функциональной применимости, конечно, связан с определениями, вынесенными Верховным судом.
Federal statutory protection for trademarks began in the 19th century. The law was revised by the Trademark Act of 1905, which was radically changed by the Trademark of 1940, Act of 1946, and which many times.
Peter, can you hear us? Peter, can you hear us?
Adopted in many states. Unlike the law in most other countries,
Доктрина функциональности была разработана на основе прецедентов, которые складывались на основании решений Верховного суда и федеральных окружных судов. В 1998 году в закон США о товарных знаках, который был принят в 1946 году, были внесены поправки, напрямую запрещающие регистрацию товарного знака, обладающего исключительно функциональной применимостью. То есть измененный параграф 2 закона США о товарных знаках предусматривает, что ни одному товарному знаку, обладающему отличительным свойством с точки зрения потребителя, не может быть отказано в регистрации на основании его характера. Но может быть отказано, если товарный знак включает в себя любой объект, который обладает исключительно функциональными свойствами.
the Supreme Court are precedents binding on all lower courts. There are 12 circuit courts of appeal. Decisions of each of these courts are precedents binding only on federal courts within its region.
Однако закон о товарных знаках не дает четкого определения функциональности, поэтому фактически сфера применения принципа функциональности зависит от толкования суда.
The Ninth Circuit has jurisdiction of the territory of the state of California.
Согласно общему английскому праву, которое было унаследовано американцами после обретения независимости, защита прав на товарные знаки основывалась исключительно на судебных прецедентах, а не на законах. Охрана товарных знаков на федеральном уровне берет свое начало после принятия закона 1881 года с изменениями.
parties engaged in
Согласно
patent
федеральному закону, при оспаривании права на фирменный стиль в случае зарегистрированного товарного знака бремя доказывания функциональности ложится на предполагаемого нарушителя, а в случае незарегистрированного товарного знака ложится на правообладателя товарного знака.
only very rarely grants such review.
На эту тему, безусловно, есть большое количество публикаций и обзоров. Одним из таких примеров есть сборник прецедентов по закону о товарных знаках США профессора Бартона Биби.
Jurisdiction over appeals in these cases.
Безусловно, решение по каждому такому прецеденту основано не только на решениях Верховного суда, но и на решениях судов апелляционных инстанций, которые могут различаться в зависимости от каждого конкретного штата. В Соединенных Штатах также у каждого штата своя собственная судебная система, и такое разделение судебных систем значительно усложняет толкование закона о товарных знаках, а как ранее упоминалось, в США защита прав на товарный знак в суде опирается, безусловно, преимущественно на прецеденты. Федеральная судебная система в США насчитывает 94 окружных суда, 13 апелляционных судов и, соответственно, 1 Верховный суд. Решение самого Верховного суда являются прецедентами, распространяющимися на все нижестоящие суды. Например, в юрисдикцию апелляционного суда 2-го округа попадает Нью-Йорк, а в 2 других восточных штата, в то время как в юрисдикцию апелляционного суда 9-го округа попадает Калифорния и 11 западных штатов. К сожалению, звук пропал.
If there's a difference in the interpretations of the trademark among various federal circuit courts.
Как уже говорилось ранее, безусловно, все судебные решения опираются на толкование закона, которое в свою очередь выливается в прецеденты.
In particular, in the time since the Supreme Court was created in 1790, it is considered only 4 cases involving trademark functionality.
Однако в спорах в отношении товарных знаков прецедентная практика толкования федерального закона различна по округам, поскольку Федеральный апелляционный суд не был наделен исключительной юрисдикцией в отношении апелляций по подобного рода делам. То есть в случае товарных знаков суд обладает не исключительной юрисдикцией только в отношении апелляций на решение апелляционного совета по товарным знакам при ведомстве США по патентам и товарным знакам. Однако решения совета также могут быть оспорены в зависимости от поданного иска в Федеральный окружной суд. В свою очередь, решения Федерального окружного суда по делам о товарных знаках являются прецедентами, распространяющимися на ведомство по патентам и товарным знакам США, включая его апелляционный совет. Но в то же время они не являются обязательными для других федеральных судов, в то время как решения судов штата о толковании закона штата о товарных знаках подлежат конституционной проверке Верховным судом, но не подлежат проверке по существу ни одним федеральным судом.
In evaluating the functionality. Second, whether the features of a product should be considered both individually and as a whole, or considered only individually in determining functionality.
Верховный суд Соединенных Штатов ежегодно получает в общей сложности порядка 5000 ходатайств о рассмотрении всех типов дел, но удовлетворяет лишь небольшую часть таких ходатайств и рассматривает порядка 70 дел ежегодно. Рассмотрение самим Верховным судом наиболее вероятно, если есть различия в толковании на уровне федеральных округов. Тем не менее, поскольку Верховный суд редко соглашается рассматривать споры по товарным знакам, проблема различия существенна и закон о товарных знаках и его толкование отдельными округами противоречие в нем сохраняется годами и даже десятилетиями. В частности, до тех пор, как Верховный суд рассмотрел с момента своего основания только 4 дела, связанных с функциональностью товарных знаков.
Provided to look to the existence of a utility patent disclosing the utilitarian advantages of the design.
В отличие от правоприменительной практики Российской Федерации и других европейских и азиатских стран, в США под закон об охране ТЗ также могут попадать случаи, относящиеся к таким объектам интеллектуальной собственности, как промышленные образцы и полезные модели. Далее это будет заметно из конкретных примеров, основанных на прецедентах.
Appellate courts, in considering two aspects of the Morton-Norwich approach, the consideration of alternative designs and the consideration of the functionality of a combination of features. In an excellent article published last year, there's a detailed discussion of the current state of alternative designs in each of the federal circuits. By the way, I include in the online version of my talk, which you can download, references to internet sites where you can get each of the sources I cite.
Решение, интерпретирующее действующую редакцию закона о товарных знаках от 1946 года, оставили без четких ответов два основных вопроса. Первый вопрос: было ли уместно и в каком случае рассматривать аналоги при оценке функциональной применимости товарного знака? И, во-вторых, следует ли рассматривать характеристики продукта в целом или характеристики продукта по отдельности? Мнения федеральных апелляционных судов разделились по этим двум вопросам. Тем не менее, для определения конкретных аспектов, является ли образец продукта де юре функциональным, на основании прецедентов в США применяются факторы Мортона-Норвича, то есть существует четырехступенчатый тест для определения функциональности знака. Первое – это условие наличия патента на полезную модель, раскрывающую функциональную применимость образца. Второе – это рекламные материалы, в которых автор рекламирует его функциональные преимущества. И третье – доступность для конкурентов функционально эквивалентных образцов. Четвертым фактором, безусловно, является указание на то, что образец приводит к сравнительно простому или дешевому способу производства продукта. Также я направил в чат более подробную информацию о прецедентах Соединенных Штатов. Возможно, вам будет интересно ознакомиться. Также сейчас на экране вы можете видеть подробную информацию с ссылками на текст доклада, а также на ссылки конкретных прецедентов, которые, безусловно, внесли большой вклад в определение функциональности товарных знаков.
Court of Appeals to the list of courts rejecting the Morton-Norwich approach. With this addition, the differences are becoming more pronounced. Further, the differences on other aspects of trademark law are also continuing. It's clear the Supreme Court is highly unlikely to find time to resolve these differences. These differences could be resolved by giving the Federal Circuit jurisdiction over all trademark appeals, just as it now has jurisdiction over all patent.
В настоящее время на экране приводился пример на относительно свежее решение, вынесенное Верховным судом США. С ним можно ознакомиться по ссылке. Но хотелось бы отметить, что не все округа окончательно рассмотрели вопрос о том, могут ли доказательства наличия альтернативных образцов или дизайнов учитываться при анализе функциональности товарного знака. Из всех округов лишь 6-й округ США, в котором рассматривалось дело так называемого Traffics, вообще отказывается рассматривать альтернативные образцы. Некоторые другие округа все-таки согласились рассматривать альтернативные образцы и обычно используют два разных подхода к определению функциональности, один из которых изначально рассматривать аналоги или альтернативные образцы как часть многофакторного теста Мортона-Норвича. К таким округам относятся 4-й, 7-й, 9-й федеральные округа. Или рассматривать альтернативные образцы как второй этап двухэтапного теста, только если товарный вид определен как нефункциональный в соответствии с традиционной практикой.
Питер,
Yes.
вы завершили свой доклад, я правильно понимаю?
Have you finished your speech?
Yes.
Yes. Yes. Thank you.
Спасибо, дорогой профессор Мэкс.
Thank you,
За
dear
ваш
Mr.
доклад. У нас
Thank you,
были
dear
некоторые
Mr.
проблемы
Max.
технического плана.
We faced some technical difficulties during your speech.
Да, но благодаря тому, что вы заранее прислали нам все материалы, мы с этой проблемой справились. Еще раз большое спасибо за то, что вы приняли участие в нашей конференции.
But thank you that you managed to forward us your report in advance, so we managed to gain deeper understanding of the functionality issues of the trademark. So we would like to express our gratitude for your participation and contribution.
Так, коллеги, а теперь я попросил бы Любовь Леонидовну рассказать, что было на секции номер 2.
So, dear colleagues,
А
now I'd
потом
like
мы с
to
Юрием
give the
Сергеевичем
floor to
расскажем, что
Любовь
было на секции
Leonidovna
номер 1.
so that she could describe the
Да, спасибо большое,
course of
Михаил
the
Александрович.
deliberations
Да,
during their
трудились
session.
на секции
Thank you
номер
so
2,
much. In
и
fact, we had a very
выслушали
productive
14
discussion
выступлений.
during our session because we
Разнообразные темы,
listened to
и
14
разные вопросы
speeches,
затрагивали
so
наши
that
уважаемые
topics
докладчики.
were very
И пообещали даже
diversified,
представить
and
письменные
our
предложения
speakers
в
actually
проект
have
резолюции
promised
в
to put
связи с
forward
этим
their
задавали
written
вопрос, сколько
propositions for the
времени у них есть для
draft
того, чтобы
resolution,
сформулировать
and
свои
their
письменные
question is
предложения,
how
нам
much
их
time do they
представить.
have to
Михаил
put
Александрович,
together
если
their
разрешите ответить на
propositions and
вопрос,
submit those
то
documents to us.
наши участники были бы
So
благодарны,
our
если бы вы
participants
дали
would
какое-то время
appreciate
для
it if you could provide them
формулирования
with
этих
some time
предложений. Давайте
so that they could,
определимся.
as I said, put together their propositions.
Хорошо. Какие есть предложения?
I agree. So,
Вот
would you
прозвучали
like to
предложения 10
suggest
дней.
some certain time frame? 10 days? No, let's say that it's tomorrow. That the draft resolution should be formalized tomorrow and then disseminated, because we cannot wait for another 10 days. So the information will be obsolete by then. So then if you are not prepared to do it today, so that we can send it tomorrow, then you can have your contributions included as articles and publications in our scientific journals. That actually was my assumption, that there wouldn't be much time available because we need to finalize all the materials. So it's tomorrow actually that we would like you to submit your propositions in written form. And then back to the substance of our discussions, just several speakers addressed point item 1, the resolution, that's Article 1225, needs to be amended so that the list of IP assets will be open. So again, the opinions of participants split, and one group substantiated their views and the other group just opposed with the arguments for keeping it as a closed list rather than leaving it in the open. So we haven't yet agreed. So the outcome of the conference as regards 1225 article on the Civil Code and whether amendments are needed or to be part of our draft resolution. So these cannot be seen as the outcome of discussions under Section 2, but at the same time I would like to state the importance and the need to continue the discussion so that we could reach a well-balanced decision with respect to this matter. Next, several points were raised in respect of conflicts of laws for different IP assets and also different legal protection mechanisms for similar assets that can be protected via different protection mechanisms, be it industrial designs, copyright objects, and at the same time we focused on those procedures that are undertaken by Rospatent when granting legal protection to industrial designs. Furthermore, we have agreed with that statement that Rospatent experts should be entitled to put forward their grounds for refusal if in the absence of copyright. So it is not formulated or enshrined as an instruction, but unlike the position of IP court, our distinguished specialists believe that experts just have an obligation to run this kind of review. And I think this is one of the conclusions that we need to include in the resolution. But obviously, this goes without saying that just the sooner we can identify all the grounds for refusal, the better it is, because the right holder then will not have to go to court to defend their rights, and the dispute can be settled out of court. Next, we also touched upon the category of IP such as work made for hire, and our specialists shared their recommendations, which could be suggested for employers. Employers could also adopt some corporate regulations for work made for hire objects and also for all the operations. And also this aspect can be regulated as part of the employment contract. However, in practice, there are many problems that are associated with a lack of regulation or with a general regulation. So if we want to reduce the level of tension in the conflict of regulation, then local bylaws are needed, some local regulations or instructions are needed to govern this issue. In addition to that, we also covered the role of protection that can be carried out by different institutions, and also we look at the scope of rights that can arise from creation. And there was one case study. So we looked at the whole array of rights that are associated with one particular work. and we discuss what can be done, I mean, what kind of legal advice can be sought, because some difficulties can emerge in terms of market operations, and then we need to also identify some potential rights. And whenever we deal with copyright, we need to have reliable sources such as database or registers that would help us navigate through the rights and probably regulate them better when new products are released into the market. I will not be able, to mention all of the points that were raised in these 14 speeches because these are far too many to cover. However, I have pinpointed those that are of greater interest. Therefore, I would like to invite the respective authors to submit their proposals for inclusion in our resolution. So, and I would like to give the floor to my colleague, who was the second moderator, just to make sure that I have covered every aspect of it. I would like to make one remark that is about commercialization or monetization of copyright in industrial manufacturing. That was this very specific aspect, because we know that the authors are searching for new models to implement their rights in production, manufacturing, in a means of individualization. At the same time, they also request more of novelty and originality. So even as compared to the present level of requirements. So this is the aspect that I find most also interesting. We have been also given some case studies or examples of how authors will either register their trademarks or they will not register them, but commercialize them or monetize them without any official registration. And I would like to give the floor to another section. Thank you very much. In fact, we didn't have that many speeches during our section. There were 11, though, and we touched upon digital technology that could serve as a tool to protect copyright. So we didn't dive into all the topics, but nevertheless we highlighted the key points in using distributed ledgers for recording and disseminating this free of charge copies. So because this tool is not employed by libraries at the moment, so we would like to continue the discussion to see what are the real prospects for it, and probably we could even offer our own technology and resources to run the testing exercise. And there was another very interesting speech on AI and technology that could serve also the purposes of IP protection. Kyrgyz Patent Agency touched upon the questions of cryptography, identifiers, and how effectively those can be used when dealing with applicants that file their applications for IP assets, and then how this cryptographic means can be used via cloud applications for the signing of documents, and which is another area that is very relevant to the current operations of Rospatent, and obviously we could continue our efforts in that direction as well. In addition to that, it is worthwhile to investigate further one proposition that we received from Mr. Sasonka, and that was about tokens that can be used for the turnover of rights. The tokenization is a bit of dubious topic, so it can be controversial at times, and we need to be very cautious, but slowly and surely moving towards better regulation. I would like to thank all of the colleagues that contributed to our discussion. I would like to invite them to put their ideas on paper in very concise format so that this could be included in our draft resolution. Thank you so much, and so I would also like to comment that our section was a success. There was one speaker was not able to participate. So we had 11 speakers, and then we started with 15 minutes as a time limit, and then again we reduced the time to 10 minutes, then to 5, and again, so we just had one speaker that didn't have time enough to deliver his speech, but that was it, because we had to conclude before action, before resuming our plenary session, and all the speeches were quite exciting, so then they were well summarized by my colleagues. So we are nearing completion, and that's the concluding remarks so that from us. So Olga Leonidovna has already mentioned that we need to now collect all the propositions and written remarks in order to put together our draft resolutions, because some provisions are a bit controversial, and this is true for 1225 article, but to me there is a very easy way to address the problem. So the resolution consists of 3 parts. So there are recommendations for lawmakers. Second part would be recommendations for the expert community, and there's the third section that are recommendations for right holders and users and so on and so forth. So what I suggest is that we collect all controversial propositions, I mean those propositions that we haven't been able to reach a consensus upon, then we can put them together under the expert community section, and then we could add this statement saying needs to be discussed, needs to be investigated or further agreed upon. So this is something that enables us to deal with this first question. Second, I would like to remind you that we've already promised that we will publish the speeches or reports, and those speeches will be published and provided that A, these are actually submitted within 1 to 10 days or 2 weeks maximum, and B, so these articles are put together in compliance with the state requirements that would include like extra key words, literature, sources, and these needs to be done in both languages, Russian and English. So these are general rules, and there's no way that we can change that, and it's not our intention to do so. Third, I would like to say that the first conference that we organized together with UNESCO chair and Rose Patent, and this took place about 18 years ago, probably 10 to 12 years ago. Nevertheless, there has been this huge break in our collaboration, and after that period of time, so we had the second chance, and our conference has been a true success. So I would like to thank all the organizers and contributors from the part of Rosputin and UNESCO chair. Yes, we did experience technical difficulties such as simultaneous interpretation, for instance, but we solved this technicality. Of course, we would prefer to have all delegates in this room, but let's face it, we are wearing masks. I mean, I'm not wearing masks just for the single purpose that you could see me, because you are far away from me. And I mean, even if I'm a carrier, so you will not be affected. But I'm fine, so I'm not. I don't have the virus. So therefore, I believe that this conference should become an annual event. And secondly, we need to think through the forms and ways of our discussions and deliberations on many of the problems that were raised today. Remember Tatiana Romashova, who is the head of the digital department at the Ministry of Culture. By the way, the topic that she raised is really insightful, and but I'm not ready to share her view. So I think that we need to discuss it in greater detail, because whenever we use some museum object, so a museum object can be a sculpture, for instance, that is physically within the museum, but the image of its sculpture cannot be considered as an object of the museum. So this image has the right holder, and the right holder would be a photographer that took a picture, and the sculpture was created by the sculptor, by someone. So probably, I mean, if the artist is still alive and the 70 period has not expired, but it's the ancient Greek culture. What to do? I mean, epithet. Remember, I mentioned the epithet in my speech, and there's no way that we can, in the book, here's words. So I believe that, again, we need to rely on this win-win principle. So this is a serious topic which we need to discuss. So, but no decision should be unilateral. This unilateral decision will not help us strike a balance, because that's the balance of interest that is the backbone of intellectual property. So we are balancing the interest of the creator and the society that will be using the results of creation. And it is exactly in this field of law that we need to rely on this win-win principle to make sure that all parties are happy. It is a hard thing to do, but if it were an easy thing, an easy task to deal with this, we wouldn't have been asked for to take it, to cope with it. So and I'm sure that through our concerted effort to achieve great results and tackle all the tasks. So, Mr. Ivlev, the floor is yours. Dear friends, we have just had a brilliant speeches and reports throughout the day. So we have this classic approach, like speeches and sections, plenary sessions, and deliberations, and that was the approach behind the conference. And I would like to agree with my colleague that this conference should be made an annual event. By the way, we can organize it as part of the Copyright Day and probably Russian Author Society. Sometimes organize, so that this society organizes events and in which we take part. And those speeches that have been delivered by Mr. Fedotov and Mr. Monoman, they should be on the agenda, but I would say that this needs to be coupled with a Q&A, with the interactive deliberations like pros and cons, or against or in favor of certain views, and then this could result in a resolution by the professional community. And I've just invited all the specialists from industrial designs and copyright, and I believe that the information is quite insightful. We're looking at the authorship. The authorship is the primary source, and Mr. Monov also made an analysis of views that are taken by the experts, and this is important. I think this needs to be implemented in our practice. And during the section, I just listened to the speech that was delivered by a young specialist, and said that compliance with copyright does not apply to industrial design or the trademark, and that was the sentence from the expert report. I mean, this is one of the conclusions, but we have this presumption of authorship that is provided for by the legislation. But if the civil code actually has the full effect with respect to all the acts by the experts, and also the head of the agency of the rules patent, because it is our obligation to respect the rights of those people that come in the remit of our powers, and that the barbarian from Siberia will be using as a principle. So because if it should be protected, and we need to monitor the use of this right. It is implicit, but when they say that the title of a book may not be included in the trademark, so that's explicit. But then in other instances where it is not expressly stated in the law, we need to base our decision on copyright, on the authorship presumption, and this is one of the principles that we stand by. So if further improvement is needed to be made towards regulation, then I would like to urge our colleagues that go to court, and also I would like to just help us get our message across. Just when we started, with this 5 centuries BC, and then the authorship was there, and the barbarian from Siberia, just the Russian film. I mean, of course, it is different from the Greek artists that painted their names on the vase. But these are, these are two things, but they are covered by this umbrella principle of the effect of copyright. Mr. Gavrila and our colleague from the United States that explained this sort of experience from another continent. And to me, it is essential so that these statements have been voiced, the views have been expressed. So let's take this Pushkin Museum, the exhibition that is very popular. It's like advertising / arts, so ed/arts. And this is the things that we're talking about. They are not abstract things. So I invite you to visit the Pushkin Museum and just to see this harmony between art and commerce. So we see how these two will come into combination. What will be the outcome? Remember, algorithm, AI, 3D. These are practical issues that are raised, and I'm very thankful and grateful to my colleagues that put forward 4 solutions. But out of 4 solutions, we need to choose the right one, and also this requires careful consideration as well. We need to be forward-looking, because we need to try and decide whether yes or no. But you remember in Volgograd case, there was this man using the computer in Volgograd, that just the computer produced a piece of craft, just some tray or ornated tray, but probably this ornated tray became a better version of something that people made, жесткого tray, or probably. So what we need to decide for ourselves what to do. Either we stick to artists, or we go with a software, programs that would be replacing artists. So we need to look at what is the object, what is at stake. We are protecting authorship, and we are protecting this creative contribution. So my special thanks go to Mr. Gavrila, who mentioned that the Grinalov is part of our classics of jurists. Again, a summary of all the stages that we have been through, and Professor Gavrilov just made it this very useful summary. And to the younger audience, so I urge you to make a step ahead. Please, based on the information that you learn from this conference, we would like you to progress, and we will provide you with every support, with your endeavors, with your decisions. So, and I would like to thank Mr. Fedor for this idea to organize this conference, because we clearly missed that kind of experience. So I would like to thank all of you for all of your contributions, and I would like to assure you that we will have implementing measures in place. So for us, it is of utmost importance that we put together this collaborative program of actions that we will be implementing, and this is one of very important deliverables of the conference. I would like to thank you for the international contribution. I would like to thank our colleagues from Eurasia that also came very united in supporting our conference, because they have their interest. Again, that's about the Eurasian integration. That is another key area of our development, and we need to have a joint stance with our colleagues from Eurasia. So we have our next conference planned, and actually we are giving this course to proceed with this theme. And I will also, of course, I'll include Mr. Fedotov's speech, and we'll allocate more time for him. So I suggest we need to start with practice-oriented conferences in order to pinpoint problems and address them in particular. So otherwise, we'll just look back to the books and then trying to search some solutions, or probably ideas from other scientists. So therefore, I would like to thank you for your concerted efforts, and I would like to wish you all the best. And I have a suggestion. Let us rename the conference, because the title goes like Scientific and Practical Conference, Copyright-Related Legal Issues and Industrial Property. Just one word needs to be added, like first first can be added as a, and then first, then second comes. Again, this has made its way into the history, and there's nothing you can change about that.